Itu tidak semua. Itu reflect tapi lo itu tidak semua. Ini dia anda dulu awal responnya bisa itu bukan
May it please my lordships. Lordship, I did mention item number 19 on behalf of Senior K.N. Chowdhury, praying for listing the matter on 30/7/2025.
37.
30th July.
Launch. 30 July.
MS Zajimumi, the learned counsel for the appellant, seeks adjournment of the case on 37/2025. Stop. The other side has no objection. Listed accordingly.
Oblige your lordships.
Obliged lordships.
Please, lordships.
Yes,
I'd like to mention item number 17. Your lordship, I have received the instruction, but they have sent it on Hindi version. So I have to return it back.
your CGC, correct?
No, no. So I may be given another 3 weeks time.
Okay. Mr. Yangarwati, the learned counsel, the learned CGC submits that he has received the instructions from the respondents. However, the instructions so received is in,
Hindi version of
he is in Hindi version.
also.
He therefore submits that some time may be granted to him to seek necessary clarifications/instructions. Listed after
3 weeks, lordship.
3 weeks. Okay.
Lordship, I also beg to mention item number 3. The court has directed so for certain clarification. Lordship, I have received the clarification. I may be allowed another 2 weeks time to
Let-
file my.
Let it come as per list.
Okay.
Let's see the order, last order.
Please, Your Lordship.
Yes.
Lordship, I beg to mention the hearing item number 18, Your Lordship.
Ah.
On behalf of Taliao, the leading counsel for the appellant,
Yes.
who is indisposed today, Your Lordship. So I pray if this matter can come up after 3 weeks, Your Lordship.
Mr.
I'm appealing on behalf of Sir Taliao.
Your
Metovero.
good name?
Metovero.
Mr. Medovero, learned counsel makes a mention on behalf of Mr. Taliao, learned counsel for the appellant, and seeks adjournment of the case for 3 weeks on the ground that The leading counsel is
Indisposed.
indisposed. Prayer is allowed, listed after 3 weeks.
Much obliged, Your Lordship.
May it please your lordship.
Yes,
Lordship, I beg to mention hearing item 14, 15, and 16, lordship.
yes.
Lordship, here the parties we have a consensus prayer. If this matter may be listed after 3 weeks, lordship.
Okay. On the prayer made by the learned counsel for the parties. Listed after 3 weeks.
Much obliged, yes.
May it please your lordships.
Yes.
Lordships, I beg to mention item number 19 of the daily list, your lordship.
19 mentioned.
Indeed, lord.
Mentioned.
Already mentioned. Much obliged.
Yes.
May I please your lordship.
Yeah.
My lord, I beg to mention item number 30.
30.
Yes, 13. Let us make they come up after 3 weeks, my lord. If we have instruction, my lord.
Let it come as per the list. Let us see.
My lord.
Let us see the last order.
For motion, item number 1.
Yes, Mr. Tucker.
Yes, Lordship, yes, the petition is there and I have served notice to the caveat.
Yeah.
Lordship, this writ appeal is directed against the judgment passed in WPC 182 of 2016. In the impugned judgment, the date of, unfortunately, the date of judgment is not reflected. The case was heard on 11th of December, and then the judgment was delivered on 16th of May. Now I have enclosed a letter from the concerned communication at page 98, which shows that the case was delivered on 16/5/2025 before the principal seat at page 98. So my respectful submission, the impugned judgment should be considered as a judgment passed on 16/5/2025. Lordship.
And not which date? The judgment, you are saying, was passed on.
No date, no date, in it.
16/5, oh, no date.
No date in the impugned judgment. The case was heard at Kohima on 11th of December 2024 and delivered on 16/5/2025 in the principal seat, and no date in the impugned judgment.
Okay.
But my respectful submission, this would be considered as on 16/5. Lordship, I'm going to raise some very important legal issues here. It is more of a legal issue than factual. The issue relates to, Lordship, whether the rule of the game or the procedure prescribed for a rule of the game can be changed after the match starts. Secondly, Lordship, whether the procedures prescribed for the examination, whether some discretion should be given to the interview board to ensure that the best person is selected. Honorable Supreme Court has dealt with those issues. And thirdly, Lordship, whether the candidate appearing for the exam have a legitimate expectation that the examination should be consistent, predictable, and transparent. And finally, Lordship, even if the selected candidates, even if the persons who are selected were found to be in violation of Article 14 and 16. In other words, they were selected after the rule of the games has been changed to the detriment of the candidates, aggrieved persons. In view of the fact that the respondents who were selected, rightly or wrongly, had continued in service for a very long period of time during the pendency of the petitions, whether, in spite of that, whether they are entitled for equitable relief. Because, Lordship, I'll show from the judgment, the constitutional, 5-bench constitutional judgment, 2 judgments, which was the subject of issue in the before a learned single bench. in those cases, the Honorable Supreme Court, even after having found that the respondents who were selected, after the rule was changed, after the game was started, and the appointments were found to be in violation of Article 14 and 16 of the Constitution. The Honorable Supreme Court had decided that the principle of equity.
You just take us to the facts. Where,
My lord, I'm coming.
which supports your case that the rules were changed after the games has started.
Yes.
Please come to that.
My lord,
Let us not go any further.
my lord, then may I go to the facts of the case little bit?
Yes. On
Lordship,
facts
fine.
to support this issue raised by this court.
Yes, yes. Then Lordship, may I kindly allow me? Lordship, may kindly allow me
What
to.
what was the rule changed after the game had
Yeah,
started?
Lordship, may kindly allow me to go to page 123. Let me highlight the facts little bit, because one of the reason why I'm highlighting the fact is I'll be going to the judgment. That's why I was trying to highlight the issue. One of there was an advertisement which is at page 124.
123.
The type copied 124, Lordship. Bear it, Lordship. Unless the facts are clear, then legal issue, but Lordship, that's why. Applications, this is an advertisement dated 21st November 2015. Note advertisement. Applications are invited in the plain paper giving full curricular.
2015 advertisement.
Yes,
2015.
2015. And I'm appointed in 2016, and I'm continuing in service for the last 9 years. I will highlight the fact. That is why kindly allow me to highlight the facts. It is not a recent appointment, Lordship.
You were Mr. Taka. You were appointed consequent to this advertisement?
Yes, and my lord, my appointment, the appointment order is at page 191. I was appointed on 3rd August 2016. Lordship,
Yes, then.
Lordship, may kindly allow me to see 189, 190, and Lordship, may kindly allow me to read 191, 189. Only in service people were invited for the interview. So I was serving as a senior inspector in the cooperative department. After my selection, Lordship, I was released. I had to resign from my old job, and I had to, and my lord, 190. Then thereafter, Lordship, may kindly see page 190, the next page. I was released after my selection, and thereafter I was appointed on 3rd of August 2016. And since then, Lordship, I'll be completing 9 years on, I'm running 9 years in the job. Lordship, kindly allow me to place the judgments on the question of.
No, let us first come to the facts.
Yes.
We
Lordship.
may not
Yes.
make that lengthy.
Lordship, yes. So, Lordship, there was the 123, Lordship, the advertisement.
Now, why are you aggrieved?
My lord, the point is this. Kindly allow me to narrate the facts. There was an advertisement in the year 2015. Then in the advertisement, Lordship, kindly allow me to show the conditions. Unless you, Lordship, I show the conditions, it may be difficult for me to explain the position. That's why I would like to narrate a little bit of facts. At page 124. Merit advertisement, the conditions. Applications are invited in a plain paper giving full curriculum vitae for serving candidates belong to the 5 tribes. That is fact, then the application should address to the Commissioner Secretary, Governor of Nagaland for the post of sectional assistant. Then the minimum terms. My lord, this is the eligibility criteria provided. Eligibility criteria: graduate, working knowledge in computers, the age, no objection certificate from the head of the department where he or she is serving, and then fixed pay employee who cannot apply. Then date and venue of written test will be informed. Then next page, 125. Lordship, the procedures, this is the procedures, how the examination will be conducted. Written exam, MCQ of total 100 marks, 50 marks for written, 30 marks for oral, and 20 for work experience. This was the first condition. This is the eligibility criteria in the procedure provided. Lordship, may kindly make the distinction between eligibility criteria in the procedures. Thereafter, Lordship may kindly come to page 131. No, 126, Lordship, page 126. After the post was advertised, and when the calling letter was issued on 8th of February 2016, Lordship, the eligibility, the procedures provided in the advertisement was further changed. May I read, Lordship? In pursuance of this Secretariat advertisement dated 21st November 2015, and your application submitted in this regard, you are hereby asked to appear before written exam on 26 March 2016. The impartial modification, Lordship, the type copy is in page 127. Kindly allow me to read it from the next page, the type copy. Rule 3, impartial modification of this secretary condition in the advertisement, the written examination shall be for a total of 200 marks, 150 marks for multiple choice questions, and 50 marks for subjective type questions. Then, Lordship may kindly allow me to come to serial number 6. Top 15 candidates will be shortlisted for an oral interview, provided they have obtained minimum 50 marks in the written exams. Then the final selection of the candidates out of those called for interview will be done as under total marks obtained in the written examination. Out of 200 will carry a weightage of 60%. Oral interview will carry a weightage of 30%. Overall assessment of work experience will carry a weightage of 10%. So, Lordship, from the advertisement of 2015, the weightage initially it was 50, 30, 20. My lord, 2015 advertisement. It was modified to 60, 30, 10 in the calling letter. So, Lordship, the rule of the king was changed after the advertisement was issued. It was accepted by all from 50, 30, 20.
Yes.
So, my lord, the rule was
So,
changed.
Mr. Taka,
Lordship.
okay. And by this advertisement, 2015, you were selected.
Yes,
Correct.
yes,
Then what happens? What was the development which took recently?
yes.
That,
I'm coming.
Yes.
I'm
Kindly
coming.
come straight to that.
Then, Lordship, kindly allow me. Then, after the condition was further changed, that's how the issue arises. That's
I
why
understood.
159, Lordship. The conditions in the calling letter was further changed.
159.
Yes, my lord. The condition was changed twice. That is why I'm trying to highlight.
This is 159 is what?
Is the meeting minutes of the board of the Governor's Secretariat. My lord, may I read? This is a meeting minutes of the selection board held on 12th July 2016. May I read, Lordship? This decision during the meeting of the selection board on scrutiny of the work
So
experience.
this is after exam.
No, before the exam. The 1 day before the exam. 1 day before the exam. Kindly allow me to return, Your Lordship will understand. My lord, a selection board meeting was held on 12th of June. The written interview was conducted, the written examination was conducted on 13th, Lordship. And this is a decision on 12th. On scrutiny of the work experience, knowledge, and proficiency in computer, educational, and professional qualification of the candidates shortlisted for written tests, the board, after taking in account the work experience and special qualification possessed by the candidates, has observed that there is a need to review the marks given for oral interview, and after detailed discussion, it was decided that the marks in the oral may be reduced from 30 to 25, and the marks for work experience, knowledge, and proficiency in computer, educational, and professional qualification may be increased from 10 to 15%. The total marks would be 40% as was given in the call letter of the candidates. 2. The final selection of the candidates out of those calls for interview will be as under. Total marks obtained in the written examination of 200 marks will carry a weightage of 60. The oral will carry a weightage of 25. The overall assessment, work assessment will be 15%. 3. The selection board members thereafter finalize the marks for work experience, knowledge, and proficiency in computer, educational, and professional qualification for all candidates. The marks given to each candidate, work experience, knowledge, and proficiency in computer, educational, and qualification is enclosed. My lord, this is important. A copy of this decision of the selection board may be put up in the notice board of the governor's secretariat for information of all the interested candidates. So, Lordship, from 3010, it was further modified to 2515, 1 day before the written exam. And the marks scored in the work experience was notified on 12 in the notice board before the candidate appeared for the written exams. Then Lordship, may kindly allow me the next 162,
This.
page 162. Page 162, married, Lordship.
Whether you were aware about this 159?
My lord, I was aware thereafter I appeared. And I was declared successful. It is the contention of the writ petitioner that the changes that was put up in the notice board, you were not aware. That is the issue. Both the parties, the first change in the calling letter, we have accepted. So the rule of the game was changed. Thereafter, the procedure out of 40%, instead of 30 then weightage, the examination board decided that since they are inviting only in-service employees and they need the best persons, they decided that out of that 40%, it should be further modified and oral interview should be 25 and the work experience should be 15. Accordingly, Lordship, on 12, the board took a decision, it was notified, and also, Lordship, the marks secured out of 15 was notified in the notice board. And thereafter, we appeared for the written examination on 13, oral interview was conducted on the 14th, and result was declared, I was appointed. Now, the main issue is that it is the condition of the writ petitioner private respondent that the changes that was put up in the notice board on 12/13, she was not aware. And rule of the game was changed without her knowledge.
So this case was also filed in the year 2016.
Lordship, then I'll show you how how this case, then Lordship may kindly allow me. Lordship may kindly allow me.
What about the?
Refer the
what
order,
about
page
the
99.
Observation of the learned single judge.
Lordship, kindly allow me to read
Just
page
jump
9,
straight to that.
page 99. Lordship,
Observation of the learned single judge.
page
Just jump to
9,
that.
how, kindly allow me why this case was decided in a case of 2D16, how it was heard only to 2014. Kindly allow me to read the order passed by this honorable court at page 99. Lordship, that will throw a light to your questions. May I read, Lordship? On page 99. For Mr. Counsel who represent the respondent number 6 submits that the principle of law on which petitioner had relied upon, that is, rule of the game cannot be changed after the game is over by referring to the decision of the Honorable Supreme Court in two particular cases, such and such, has been referred to a large bench of the Honorable Court by the order passed in Tej Prakash Patak, in others versus Rajasthan High Court, in others report in such and such in file. Therefore, hearing this matter may be deferred till the larger bench of the Honorable Supreme Court takes a decision on the principles of law relied upon by the petitioner. Counsel for the petitioner also supports the same opinion. Considering the facts and circumstances of the case in the principle on which the petitioner has relied upon, I am also of the view with the learned counsel. Therefore, let this matter be listed after a decision of the larger bench in the Supreme Court. So, my lord, there was a split decision. So, reference was made in the Honorable Supreme Court, and it was referred to a larger bench.
Split decision before?
Before the Honorable Supreme Court on these two issues, to two judgments.
Okay.
Thereafter, so it was referred to a larger bench, a 5-bench constitutional bench. And Lordship, the 5-bench constitutional bench in Tej Prakash, it was decided only on 7/11/2024.
Okay.
And prior to that, the same 5-bench constitutional bench also had passed a similar judgment in Sivananda versus High Court of Kerala on 12/7/2023. So after those judgments were delivered only on the basis of the law laid down in these two judgments, constitutional bench judgments, the case was heard on 11 December 2024. And the Learned Single Bench has decided pass the imbued order. Now, Lordship, I will be relying.
Single judge order is in accordance with the judgment passed by the Honorable Supreme.
No, that is the point. With due respect, Lordship, I shall be referring to the Learned Single Judge in the judgments of the Honorable Supreme Court in two judges, the 4 cases, and another 4 cases passed by the learned high courts all over the country on the same subject matter. To impress upon your lordship that the learned single judge did not.
Don't give us too many judgments. Just rely on one constitutional bench and the order.
Lordship, yes, yes. No, Lordship. So that is the issue.
What is the constitutional judge?
No, the constitutional judgment says, my lord, the constitutional bench judgments, the 2 judges, they had decided the case on 2 limbs. One, legality of the examination. And on the legality of the judgment, legality of the examination process, the Honorable Supreme Court had decided on the eligibility criteria and the procedure to be adopted by the interview board. Now, in both the judgments, Honorable Supreme Court has held that the eligibility criteria cannot be changed. 1. However, the Honorable Supreme Court has held that some discretionary power should be given to the examination board to adopt a procedure which should be predictable and fair, so that the best person should be appointed. For example, whether there should be a written exam or both written in oral, what will be the cutoff marks, how many marks to be given, those are the procedures. Yes.
Yes. Only the Supreme Court constitutional bench judgment.
Yes.
Which para?
Lordship, yes. Kindly allow me to refer to my notes so that I will refer. My lord, the first one is Sivananda.
Sivananda CT.
Yes.
Yes.
Now, Lordship, in this case, kindly allow me to give a page. Lordship, you kindly see the facts from paragraph 1 to 9 is the facts of the case.
Let us come to the observation.
Lordship,
Let us
fine.
come to the observation.
Lordship, fine. Most welcome. Lordship, I am reading from 54.
Page.
Paragraph 54.
rules does not apply with equal strictness.
High Court decisions to fails the High Court decision also fails to satisfy the test
No, no,
54.
which page 50, para 54?
Paragraph 54, page 33, but it is paragraph 54 in the first judgment.
Yes.
Merit. The High Court, my lord, here, prefix,
Please read.
interview was conducted.
Please read.
Right, Lordship. The High Court decision also fails to satisfy the test of consistency and predictability as it contravenes the established practice. The High Court did not impose a requirement of a minimum cutoff for the viva voice for the selection to the post of District Session Judge for 2013-2014. Although the High Court's justification, when analyzed in its own term, is compelling, it is not grounded in legality. The High Court decision to apply the minimum cutoff for the viva voice frustrated the substantive legitimate expectation of the petitioner. Since the decision of the High Court is legally untenable and fails on the touchstones of fairness, consistency, and predictability, we hold that such a course of action is arbitrary, violative of Article 14. What should this court do? The question which now arises before the court is in regard to relief which can be granted to the petitioners. The final list of the successful candidates was issued on 6/3/2017. The candidates who have been selected have been working as district and session judges for about 6 years. In the meantime, all the petitioners who were before the court have not functioned in judicial office. At this lapse of time, it may be difficult to direct the unseating of the candidates who have performed their duties. Unseating them at this stage would be contrary to public interest since they have gained experience as judicial officers in the service of state of Kerala. Well, the grievance of the petitioner is that if the aggregate of marks in the written in viva voice were taken into account, he would rank higher than 3 candidates who are respondents to this proceedings. Equally, we cannot lose sight of the fact that all the selected candidates were otherwise qualified for judicial office and have been working over a length of time. Unseating them would be, besides being harsh, result in the situation where the higher judiciary would lose the service of 6 duly qualified candidates who had gained experience over the last 6 years in the post of district judge. For the above reasons, we have come to the conclusion that it would not be possible to direct the induction of the petitioners into the higher judicial service at the present stage. Many of the petitioners would have since joined the bar and would be in active practice. It needs to be clarified that they are having failed to gain selection to the higher judicial service in the process, which was initiated on 30/9/2015. It is not reflection either on their merits or ability and shall not come in the way of their being considered for any other office, judicial or otherwise, in the future. Conclusions. The following are the conclusions in view of the above discussions. The principles of good administration require that the decision of the public authority must withstand the test of consistency, transparency, and predictability to avoid being termed as arbitrary, violative of Article 14. An individual who claims a benefit or entitlement based on the doctrine of substantive legitimate expectation has to establish the following: the legitimacy of the expectation and the denial of the legitimate expectation led to violation of Article 14. A public authority must objectively demonstrate by placing relevant materials before the court that its decision was in the public interest to frustrate a claim of legitimate expectation. The decision of the High Court of Kerala to apply a minimum cutoff to the viva voice is contrary to the rules. The High Court decision to apply the minimum cutoff marks to the viva voice so frustrate the substantive legitimate expectation. In terms of the relief, we hold that it would be contrary to public interest to direct the induction of the petitioners into the higher judicial service after a lapse of more than 6 years. Candidates who have been qualified 6 years ago cannot be unseated. They were all qualified and have been serving the district judiciary of the state. Unseating them at this stage would be contrary to the public interest. To induct the petitioners would be to bring in new candidates in preference to those who are holding judicial office for a length of time. To deprive the state and its citizens of the benefit of their experienced judicial officer at a senior position would not be in the public interest. In view of that, we have taken in the above terms, we have not considered it necessary to answer the broader question which has been referred to the constitution bench. Then, my lord, the other
Mr. Taka,
lordship.
Mr. Taka, the petitioner had in the writ petition challenge your appointment.
Yes,
Correct.
yes.
Why are you actually impleading all this selection board members?
My lord, there were parties in the lower court. Before
In the lower court?
before the single bench.
So they're pro forma, in fact.
That's why I called
They're
them, I have implicated as pro forma, not as main respondents.
Okay, so the main respondent is the petitioner only.
Yes,
And what was the ground of challenge?
the ground of challenge is that the changes made on 12 by the board. After the petitioner had no grievance with regard to the changes in the calling letters. Thereafter, when the changes was made by the board on 12, and it was published in the notice board allowing the marks secured, and the written exam was held on the 13th.
Whether the petitioner set for the written exam?
Yes, she said for the exam, not successful. But after that RTI was filed, she obtained the necessary information and she's filing the writ petition on the ground that she was not aware of what was notified on the 12th.
After sitting for the exam?
Yes. So my respectful submission at this stage,
Yes.
my lord, thereafter, lordship, in all the judgments that I'm referring, there are about 5-6 judgments. Leaving aside the merit of the case, the fact that the petitioners has been continuing. So my respectful submission, let the case be admitted. The petitioner is respondent, writ petitioner is also serving as a LTA in the transport department at the moment. Presently, because it is only in service people who were called for interview. So whoever is selected has to resign and join. Now, this aspect of the equity, if your lordship may kindly say the judgment of the honorable, the learned single judge in the last 2 pages, he refuse to give the benefit of this equity to the fact that when the case was heard, I was serving for the last 8 years after resigning my job as a senior inspector in the cooperative department. In fact, all the similarly situated persons in the corporation are already promoted to a higher grade. So my respectful submission is, since caveats are present, this case made, because the larger legal issues, my lord, and lordship, another important issue, an argument can be made that under only the Honorable Supreme Court under Article 142 of the Constitution have the power of equity to. That argument may be taken, but lordship, reading Article 141 and 142 of the Constitution, lordship, I have relied on I am producing 4 judgments of the other high courts, relying on the constitutional bench judgments. Lordship, power of equity to do complete justice has been extended by all the other high courts. Unfortunately, the learned single judge had failed to extend even presuming in not admitting the fact that my appointment was in violation of 14 and 16, the fact that I have been continuing now running 9 years. And lordship, there is no allegation of fraud.
Mr. Ezo, you have sat for the exam. And after failing to qualify the exam, you are coming before this court.
My lord,
I think, there are
I'll not
some further-
open the file, but I'll just.
You have not opened the file.
I'll just give the clear picture here,
Okay.
if lordship permits. There are 2 Supreme Court judgments which in my favor, that the criteria of the selection cannot be altered or changed in simple way. Rule of the game cannot be changed.
Yes.
Normally we call it.
Yes, but
Now-
it is subject
now-
to exception.
now
It is
what-
subject to exception if you have participated.
Yes.
My lordship, I may be allowed to say this. This advertisement was issued on 21 November 15, inviting application for the post of Governor Secretary Assistant Kohima, Nagaland. Then in terms of the advertisement, calling letter was issued on 8 February 2016 to all of us with partial modification.
Those are facts. You come to
Yes,
the point.
now,
Be precise.
so that lordship will have the clear picture
have
about
got
what
it.
is the case.
We have got the picture.
Now and after
Yes.
that, after the advertisement was issued, calling letter was issued, then the criteria of the advertisement was altered, changed. Now that was not brought to all of us, to our notice. Then written examination was held on 13/7/2016. Then on the same day, the day written examination was held. I don't want to say, but the board member was of the view that the R6 may not reach the target. So they had to modify it. On the same day, the day written examination was held. So therefore, after the decisions of the board members, what happened is this. Initially, as per the advertisement, the work experience carries 10% weightage. But in the written, apparently R6 got less. So therefore, in order to help R6, board member had to increase the percentage in oral from 10 to 15.
No, these
From-
changes were effected before the exam.
No, on the day of examination also, 13/7.
No, Lordship.
Two changes, my lord.
Mine is on 12th.
No. One is on 12/7/2016 and one is on 13/7/2016 on the day examination was held. There are two changes. So now what happened? With the change of the percentage for work experience, the weightage from 10 to 15, it was enhanced to 15, so that the RC will be given some percentage more than what she deserved in the oral. In oral, Lordship knows that if the members wanted to help Mr. A, they can do orally. They can ask easy question, for example. Now that is how R6 was given higher percentage. Now, therefore, then finally on 14/7, after the minute was reviewed, DPC was held on 13, 14 oral was held. On 14 oral was held. Now, result was not published immediately. Then result was published on 3/8/2016. No information was published in newspaper about the result. No result was not declared in any form. It was quietly issued to the R6. So not only me, all of us were in the dark about the appointment of R6. Lately, we were anxiously waiting that I should be selected because I did very well in written, because I secured higher than R6 in written. So I was anticipating. Result never published, no information. Finally, I was compelled to file RTI. Then through RTI only, I was informed that no appointment was already issued on March 8, 2016. So this is how it has happened. Now, for that, writ petitioner came before this Honorable High Court challenging the appointment order because the rule of the game cannot be changed once it is set in. This is the argument. That is the argument. So now while the matter was about to be finalized before this writ court, on 4/8/2017, when we were making argument, my learned friend, counterpart, he had mentioned to the court, look, similar case has been pending in Supreme Court and referred to larger bench. So that is what Justice Sarto, he passed the order to defer the matter, and that's how it was delayed till 2024. Now, Lordship will see, I'll just show the learned single judge judgment, why it is correct and valid. And the argument advanced by my learned senior counterpart, I'll just show to
Then a single judge made an
Correct.
observation on
No, no.
on you're actually like sitting for the exam despite the
Lordship,
Lordship will come, let me
give me
allow.
the observation, but I'm aggrieved by that.
So, Lordship, what my learned counterpart has made is about the issue that the judges, district court judges sitting cannot be unseated is because the advocate were not employed for the last 6 years. In this case, both of us have equal experience. So therefore, Supreme Court, High Court has held. I'll just read it out. Lordship, actually, the operative part is 43, start from 43, but I'll just read it out from 44, page 92. Operative part of the learned single judge judgment, where the learned single judge has refer the Supreme Court judgment to two judgments. Paragraph page 92, running page 92, paragraph 44 and 45. May I read, my lord?
Yes.
May I read it? 44.
Yes.
When the facts and circumstances of the present case, as discussed above, are examined by taking into purview such well-settled proposition, it clearly emerges that the changes made in the weightages earmarked by the selection board for the two segments, oral interview 30% and work experience, knowledge and proficiency in computer, educational and professional qualification 10% before 8/2/26. That means before advertisement could not have been changed from 25% to 15, respectively on 12/7/16. Similarly, the minimum eligibility marks of 50% for the written examination fixed by the selection board before 8/2/16 to qualify for the oral interview could not have been reduced to 45% on 13/7/16. That too, when the written examination was over and the marks for all the candidates were assessed and known. The decisions taken by the selection board on 12/7/16 and 13/7/16 have failed to pass the test of fairness, consistency, transparency, and predictability, and consequently, these decisions taken in the course of the decision-making process leading to the final selection are found unsustainable in the law on the touchstone of the principles of equality embedded in Article 14 and 16 of the Constitution of India. 45. The elements of arbitrariness and discrimination had entered into the selection process from the stage subsequent to the decision taken by the selection board on 12/7/2016 and 13/7/16 to change the criteria of selection. The decision taken by the selection board on 12/7/16 and 13/7/16 are held to be impermissible in law as they were part of the decision-making process leading to the impugned order dated 3/8/16. As the impugned order dated 3/8/16, this is appointment order, was a result of such decision-making process, fraud with the illegalities of the above nature, the impugned order dated 3/8/2016 is also liable to be set aside and quashed. This is accordingly quashed, so appointment is quashed. As the final results prepared and declared by the selection board to select the candidate for appointment to the post of Secretariat Assistant in the establishments of Governor Secretariat, Nagaland, are also found fraud with illegalities. The same are also interfered with. Now coming to the Lordship, I'll read it 46, 47, equally important, my lord. I'll just up to 50, I'll read it out. This court is not oblivious of the proposition that in exercise the power of judicial review, it should not interfere with the marks made by the members of the selection board and should not embark on an exercise to assess the competitive merits of the candidates. Thus, this court is refraining itself from making any competitive analysis as regards the marks secured by the participating candidates in the three segments of the selection process. That is 1, written examination, 2, oral interview, 3, work experience, knowledge, and proficiency in computer, educational, and professional qualification. 48. There was no defect in the advertisement dated 21/11/15. There is no fault found in the selection criteria set forth in the calling letter dated 8/2/16. As the elements of arbitrariness and discrimination had crept into the selection process from the stage subsequent to setting forth the selection criteria on 8/2/16. The decision taken by the selection board on 12/7/16 and 13/7/16 to change the criteria for selection cannot be acted upon as they were part of the decision-making process leading to the impugned order dated 3/8/16. As the marks in the two segments, A, the oral interview, and B, the work experience, knowledge, and proficiency in computer, educational, and professional qualification, were already awarded by the selection board on the basis of weightages at 25% and 15% respectively. Such weightages are required to be scaled up and scaled down to 30% and 10% respectively. In terms of the selection criteria notified through the call letter dated 8/2026. Thereafter, the marks already awarded to the participant candidates, including the petitioner and respondent 6, are to be proportionately awarded in the final list of marks. 49. In the light of the above discussion and for the observations made, the findings reached at and for the reasons assigned above, this writ petition is disposed with the following directions. A. 1. The official respondent shall proceed to award the marks of the candidates for 2 segments of the selection process. A. The oral interview and work experience, knowledge, and profession in computer, educational, and professional qualification from the marks already awarded to them on the basis of the weightages or for the said 2 segments at 25 and 15 respectively. 2. As such, marks are to be awarded to the 2 segments. A. The oral interview, and B. Work experience, knowledge, and profession in computer, educational, and professional qualification for the weightages of 30 and 10 respectively. The official respondent shall accordingly scale up and scale down the marks awarded earlier to the candidates, which were given on the basis of weightages at 25% and 15 respectively. 3. In the minutes of the meeting of the selection board held on 13/7/16, it was recorded that only 3 candidates had secured 50% marks in the written examination. Apart from the petitioner, the other candidate did not challenge the appointment of the respondent 6. If such is the position, then the exercise is to be made limited to the petitioner and the respondent 6 only. The official respondent shall only allot marks to the petitioner and the respondent number 6 who had qualified in the written examination and to appear in the oral interview by securing 50% mark out of 200 marks in the written examination, meaning thereby the exercise is not to be made for all the remaining candidates. 4. After proportionately awarding the marks for the 2 segments, A. The oral interview, and B. Work experience, knowledge, and proficiency in computer, educational, and professional qualifications, the official respondent shall prepare the merit list on the basis of the aggregate marks secured by the petitioner and the respondent 6 in all 3 segments of selection process. 5. After preparing the merit list on the basis of the aggregate marks secured by the petitioner and the respondent 6, the official respondent shall proceed to appoint the candidate who has secured the higher marks to the post of Secretariat Assistant in the Governor's Secretariat, Nagaland. 6. The entire exercise to be completed within a period of 1 month from the date of this order. 50 is 11, 51 months. The submission of the Land Council appearing for the respondent number 6 made on the basis of the decision in Sivanandan C.T. Supra is considered. After due consideration, this court finds no similarity to provide the same relief as in Sivanandan C.T. Supra to the respondent 6 in the event the respondent number 6 does not emerge as the candidate securing the higher marks between the 2. From the advertisement 12/21/11/15, it is evident that the selection process was made limited only to candidates who were already serving in the government with a scale of pay. If during the pendency of the writ petition, the petitioner is rendering service in her post in the Transport Department, Government of Nagaland, then the petitioner is also gaining experience like the respondent number 6, who has gained experience in the post of Secretariat Assistant since her appointment on 3/8/16. Thus, the case of the petitioner hearing cannot be equated with the petitioner in Sivanandan C.T. Supra to reach a view that if the petitioner emerges as a selected candidate for appointment, the same would be contrary to the public interest. 51. At the same time, this court cannot remain oblivious of the situation that would result if the respondent number 6 does not emerge as the candidate with a higher aggregate marks after completion of the exercise, as directed in paragraph 49 above. The respondent number 6 must have joined the post of Secretary Assistant on the basis of the impugned order dated 3/8/16 after leaving her earlier post. Her removal from the said post would definitely bring hardship and inconvenience to her. If the petitioner is still serving in a post with scale of pay and is not inclined to join in the post of Secretariat Assistant in the Governor's Secretariat, Nagaland after lapse of such long period, then it is open for the petitioner to inform the official respondent accordingly. In such a case, the exercise directed in paragraph 49 above is not to be undertaken, and the appointment of the respondent 6 is not to be disturbed. If the petitioner expresses her inclination to join, this court would further like to observe that for adjustment of equities, that if after the exercise, as directed above, the respondent 6 emerges second in terms of merit, and if there is a second vacancy in the Governor's Secretariat Nagaland, then the official respondent would consider her case for absorption appropriately. If any such appointment is made, it has to be treated as a fresh appointment, and the interseasonality has to be fixed accordingly. My lord, therefore, now I'll come to the interpretation.
Okay,
Now, my lordship.
Yes, we
Now,
are passing
my-
the order. Yes.
My lord, just 1 second, if lordship permit. As the learned single judge has pointed out, in both the cases, Supreme Court has held that rule of the game cannot be changed.
That'll be a subject matter of merit. That'll be a subject matter of merit. Heard, Mr. Takamasa? Learned senior counsel. Assisted by Mr. Aaron Law, learned senior counsel for the appellant. Stop, admit the appeal, returnable after 4 weeks.
2 weeks, my lord. Both of us, we need early disposal in this case, my lord.
There are other respondents, let us see.
The rest are all performer only.
4
But
weeks.
at least effecting notice would be
Ah,
necessary. Lordship, I have filed an IA for stay of the judgment until further orders, since the respondents are, cavitators are also present today.
My lord, I object to that because that will be in violation of Supreme Court judgment.
what was that? Returnable after 4 weeks. Issue notice to the respondents. Since Mr. Azo, learned counsel. No, Mr. Azo, learned counsel appears for the respondent petitioner and one and
2, lordship, 2 to 6, lordship.
and Mr. Kiangami, learned senior government advocate, appears for the respondent number 2 to 6. Have you served the copies?
It's already said, Lordship.
Always, we have received.
Copies of the appeal petition has been served to the learned counsel for the respondents.
Lordship, I'll be needing requisite copy.
We will supply in the course of the day. In the course of the day.
Extra copies be furnished to the learned government advocate in the course of the day. In the interim, considering that the issue raised in the appeal needs further examination. Which is the impugned judgment and order?
3/8/2000.
The impugned judgment and order dated
3/8/2005.
16/5.
The impugned judgment order passed,
Sorry.
order passed on
16/5/2025.
Yes.
in WPC 182
Passed in WPC 182/2016. Shall remain suspended till the next returnable date. Okay.
Lordship, then the IA may be, my IA may be discharged.
Caveat stance discharge.
My lord, I also file a separate IA for interim, that also may be discharged.
The, which is your, that interim,
IA 90,
the IA 78 of 2025? Seeking for suspension, stay/suspension of the operation of the impugned judgment and order deed 16/5/2025 in WPC number 182/2016. Also stands disposed.
Much obliged.
much obliged. Judgment.
For admission, item number 2.
Yes, Mr. Moa, what is? Yes, what is the last order? What was the last order?
3/4/2025.
Work completed,
No, Lordship.
31/5/2025,
I filed in the affidavit this morning, Lordship, explaining why
stating compliance.
the circumstances why we could not complete.
Why? What is the circumstances?
Lordship, the work order was issued in the month of February, Lordship, and this for a period of 30 days to be completed on 31st of May. Lordship, I have stated in my affidavit, which was filed.
But your deputy manager, general manager has given an assurance that the work will be completed on
Lordship, I agree.
25,
Lordship, I
on
agree,
31st.
Lordship. I agree, Lord. In the affidavit which I filed this morning, Lordship, paragraph 6, I've stated that for the last 90 days, in the 90 days, there was rainfall on 38 days, Lordship, 5 days in the month of March, 12 days in the month of April.
You are all taking excuse under this rain, under this.
Lordship has also seen what has happened just recently on 31st, Lordship. 100 meters of road was completely
Besides that, let us forget about that, that we know, that is completely washed away.
Lordship.
What about the other portion? Have you completed?
Lordship, only 300 meters of BCs left to be completed, Lordship. And because of the rain, Lordship, it could not be completed.
Where have you stated?
Paragraph 6, Lordship. If I may be allowed to read it from paragraph 5, Lord. Paragraph 5. That a contractor has completed 56.25% of the work. Flag topping with DBM has been completed over the WMM layer, except at 2 locations, affecting a length of approximately 300 meters. In the complete road stage, which could not be done due to early monsoon in the area. However, the complete stage is moderable in a good traffic-worthy condition. 6, it is pertinent to mention that the works were unable to be completed by the contractor due to unseasonal rains and early monsoon affecting the areas. The details of daily rainfall data acquired from Meteorological Observatory Kohima is attached for rain.
Okay, every year there will be rainfall. When can you complete? Every year there is rainfall. And when this case has been lingering on for the last, I think, 8-10 years. So every year rainfall is there. You are always giving excuse. On good weather days, you are not actually taking any effort to complete the work. On bad weather days, you blame the weather. So
The work could not be executed on time because of the earlier contractor.
So when can you complete?
Lordship, if
If you don't complete, we will seek for the personal appearance of the highest officer. Who is it?
Lordship, if we have a working window, Lordship, we can complete it.
No.
But
Every time I think this cannot be allowed.
till the monsoon is set in, Lordship. Lordship,
Monsoon was there since last 10 years. Every time you're taking the excuse of monsoon, bad weather.
Lordship, I'm appearing for respondent number 13, the contractor, Lordship. Now, Lordship, here we are in the stage of blacktopping the road, Lordship, blacktopping. And the blacktopping cannot be done in the rainy season, Lordship. And because of the unseasonal monsoon rain that has come, Lordship, unprecedented rainfall that is happening. Lordship, we could not do the road. We will do the work, Lordship, but the blacktopping will get spoiled again. Lordship, it's not that we are not complying with the order of the court.
Give us a date, both of you.
May it please, your lordships.
Yes.
Your lordships, if I may refer your lordships to paragraph 8 of the affidavit which has been filed this morning. Now, your lordships, the road below Kisama in Pesama village area, the Pesama village area, is about 100 meters. That road has been completely washed away, not just completely washed away, the road has disappeared into rubble and loose earth. So in this portion, the NHDCL may have to rethink its strategy, devise a new engineering package for this particular stretch. Otherwise, the same thing will happen again and again.
That I think will also have to involve acquisition of the land.
Yes, that is what they mentioned here, lordships. So now because of what has happened, the construction of this road is going to take a little longer than we anticipated, your lordship.
Lordship, and the material we have to transport. Now the road is not there, Lordship.
Good excuse. Really got a good excuse, eh?
Lordship, there's a MOD guideline also with regard to the
The NHDCL will have to rethink its engineering strategy, your lordships. If they persist on just filling up the land and then constructing the road above it, it is not going to be a durable road. The engineering design must change. And perhaps that will involve changing the scope of the work, the actual contract in question, your lordships.
Mommy, if the scope of the work is to be changed, then in that case, the involvement of the state government is necessary.
For the acquisition of land.
Yes.
But that is up to the MOD then, your lordship.
Lordship, as far as the blacktopping is concerned, Lordship, there's a guideline from the MOD also, Ministry of Road Transport and Highway. Lordship, 501.5.1, Lordship, can you see?
We only hope that next time you will not bring any new guidelines. Because every time the matter is fixed, every time the new guideline is there.
No, Lordship, as
And
far as
we are always on the new guidelines, forgetting about the completion of the work.
yes, Lordship. Now we cannot do the blacktopping. The laying shall be suspended in presence of standing water on the surface, Lordship. This because of the rainfall, Lordship. Well, Lordship, we understand the concern of the court as far as the road construction is concerned, but there are certain guidelines we have to follow also, Lordship, as a contractor. So this is unless you're still thinking about the disallowance. We do.
So what is best? What can be done best?
What is the solution that
We
there has to
we
be?
can't predict the rain, Lordship. And it's not only the state of Nagaland, the whole Northeast is raining under rain. Lordship.
But this portion, it happens every year, this particular portion.
They are blessed
there
with,
has to be a
they're blessed with the
permanent-
water. Too much water. But how good. They don't want to give it to us. So some consideration has been made, Lordship, but this is my humble suggestion, Lordship. Because I will build the road, Lordship, but in the process, it will not sustain for long. Lordship, as stated, we have left with only 300 meters as per the report of the NHDCL.
May I suggest, my lords,
So it is,
that
it is beyond the landslide area,
Yes, Lordship.
beyond the
The
landslide.
landslide area was already blacktop, Lordship.
Oh,
It was completed. It was completed.
yes, it completely sunk and disappeared, your lordships.
After we completed, the road disappeared. because of the landslide.
That is why, Your Lordship, the submission that probably the engineering strategy has to be revisited. Perhaps the NHADCL can be directed to submit an action plan by way of affidavit, Your Lordships.
We give you some time
As per the instruction received.
to submit what is the best viable means.
Yes.
So the road is restored for
We
enabling
have
the vehicles.
invited the experts from headquarters Delhi, Lordship, as far as this 100 meters is concerned. So they will be constituting a committee in a period of 5 days. So the committee will come up with a proposal. We can submit a proposal, Lordship, for a temporary solution, Lordship. And for a permanent solution, Lordship, and for temporary arrangement within 15 days, Lordship, we will initiate earth cutting, Lordship. Air cutting, oh, thank you so much. Then the instruction.
We have constituted a committee.
We'll be constituting a committee within a period of 5 days, Lordship. The expert committee will be arriving from headquarters New Delhi, Lordship. And they will submit a proposal, Lordship. So 2 weeks, 1 week. But the proposal, proposal could be 2 weeks from now, then we'll begin secondary report of the. 2 weeks. It has to be there for too long. Previous will go in the and then what is proposed? There's what we think that we really guiding. Also, this issue was also taken up with the state government and the for land acquisition also. It is also under consideration by the state government.
So, Mr. Muzuri,
Lordship.
after the stretch of the road which is completely washed away,
Lordship.
after this is restored only, you can actually like
Yes.
complete.
Now, we don't know what will be the proposal. Because to come with a permanent solution, Lordship, the whole hillock has been washed away. So the question of building a road, Lordship, that's far beyond imagination,
So
Lordship.
the portion which is yet to be constructed is beyond the.
Yes, beyond. So the 300-meter that is left, Lordship, yes. So that's.
Mr. Ajmani. Learned Council. Learned amicus skills. Mr. Timson. The learned additional AG for the state respondents. Mr. Muzi, you are for?
13 and 14, but 14 has completed his work. So 14 is.
Mr. N. Muzi. Learned Council for the respondent number 13 and 14. Mr. Majamia, Learned Council for the
128.
128, and Mr. Santiago, the Learned Council for the respondent number 10. Where is that last order?
3, 4, 20. 3rd of April 2025.
We have perused the order dated 3/4/2025 passed by this court. And in the light of the state order, the respondent number
8.
2 and 8, 2 and 8 has filed the affidavit dated for 6/20/25. paragraph 5, 6, and 8 of the affidavit are reproduced in below. Okay? 5, 6, and 8. New para, Mr. Mojamir. Learned counsel for the respondent number 2 and 8 submits that with regard to the stretch of the road, measuring about 100 meters, which has been completely washed out near Kisama exit gate under Kisama village area. Who has constituted the committee? Respondent number 2 and 8?
2 and 8, Lordship.
Comma, the respondent number 2 and 8.
Any changes number do you know?
Constituted
Will be considering within a period of 5
the
years.
respondent number 2 and 8.
What if the judicial number may be reflected, Lordship, on location where the
Within bracket, chainage
191 plus 950,
191 plus
950, Lordship,
950
to 192 plus 050
to 192
plus 050.
plus 050. What was the last? Mr. Kevin? Within bracket? Within bracket, na? Within bracket, the learned counsel for the respondent number, Mr. Muajamir, learned counsel submits that. An expert committee has been proposed to be set up
Lordship,
at the earliest,
Lordship.
and the committee will be submitting the report.
A proposal, Lord,
What proposal after?
for temporary solution.
And the committee will examine and submit the proposal as to what best can be done for the stretch of the road, which has been completely washed away. In that way of the matter, Mr. Mojamir submits that. How much time? 3 weeks' time may be granted to the respondent number 2 and 8 to place the expert committee proposal before the court. Stop. 3 weeks' time is accordingly granted. No, prayer is allowed. 3 weeks' time is accordingly granted to the respondent number 2 and 8 to submit the expert committee proposal in the form of an affidavit. Oh, okay.
Bless your Lordship.
Lordship, right.
For admission, item number 3.
Ma'am, this matter.
Yes.
What I'm mentioning on behalf of Senior Gauhati for the respondent.
Please call that. The mothers. 3.
Yes, my lord.
Ah,
Item number 3. On behalf of Gauhati for the respondent number 1. My lord, we have received an instruction, so if 3 weeks time will be given to me.
Instructions on the order dated 14/5/2025.
Yes, my lord, they are well aware about this.
You have received the instructions?
Yes, my lord, we have received an instruction.
How much time required for
3
filing?
weeks, my
affidavit?
lord.
I think the instructions will be very short. Why not take 2 weeks?
Yes, my lord.
Whether the stretch is included or not, that's all.
Lordship.
Yes, my lord.
We give you 2 weeks time.
If 2 weeks time may be given, because after the preparations, we'll be sending back again to the ministry for the signature, my lord. So,
Your good name,
Ching Yang Ho, my lord.
Mr. Swenso. Appears on behalf of Mr. Yangarwati, the learned CGC, and submits that in terms of the order dated 14/5/2025, instructions has been received. The learned CGC accordingly prays for 3 weeks' time to file the instructions in the form of an affidavit. Prayer is allowed, listed accordingly.
My lord. Obliged, my lord.
Should like.
For admission, item numbers 4 and 5. May I please, Lordship?
Yes.
Your Lordship, pertaining to this instant matter, we have already received the paper book. However, we need some time for preparation, so if 4 weeks may be given for preparation.
Mr. Kiangami, have you also received?
Yes, yes.
Yes.
It is submitted by the learned counsel for the parties. That paper books are ready. And the matter can be listed for hearing. Listed for hearing in the usual course.
For admission, item number 6.
Yes, Lordship.
Yes.
Lordship, by the last order, I was directed to file an affidavit placing on record the document that I have, Lordship.
Your affidavit is dated?
Lordship, I have sent it for signature, Lordship, the officer. He's only arriving today, Lordship. So by Friday, I'll be filing, Lordship. Now, as far as the issue is concerned, Lordship, now, as per the meeting that was held at Delhi, now the insurance company has committed that they will clear the pending dues of the hospitals. Now, as of date, Lordship, they have cleared 8.93 CR out of the due of 32 CR. And as per the meeting minute, Lordship, it's placed before the court. The second page, Lordship.
In your affidavit?
No, I have not filed affidavit, but it was placed on record also. One document, Lordship, meeting minutes held on 7/5/2025. Yes. It was reflected in the order also. It's placed on record, but I'll be filing an affidavit placing on record by way of.
What is the last order?
Lordship, the last order.
Was 10/5. The minutes of the meeting.
14.5, the Lordship.
14.5,
sorry.
Yes. What affidavit do you want to file, Mr.?
To place on record this meeting minutes, Lordship. Now, Lordship, as far as the dues of the hospitals are concerned, the earlier insurance, Lordship, out of the total due of 32.50 something CR, Lordship, they have cleared only 8.93.
What about the remaining?
They are yet to, the FGI is yet to clear.
Yes.
Remaining will pay, Lordship.
When?
Actually, Lordship, this is a public money involved, and we have received exaggerated claims. Those are under scrutiny. So we have to pay till 31st
That
March.
cannot be an excuse.
No, Lordship, we have received various fraudulent claims, and we have flagged it to the government also.
From what source have you received that claim?
Lordship, we have audited, we have submitted a copy to the government also, Lordship. So this is under process and the claims are under scrutiny. Lordship, total claims we have received so far was 54,340 something.
54,000?
342 total claims we have received. Individual claims, Lordship.
54,000 claims.
Out of the 37,572 we have already paid, Lordship. After disengagement, we have also paid some more amount, Lordship. So some of the claims are under scrutiny.
Why don't you place your submission in the form of an affidavit?
Our affidavit is on record. Our affidavit is on record. I filed our affidavit in opposition, Lordship.
That is on record.
Yes. The affidavit was filed before the meeting was held.
Correct, Lordship. That is correct.
The meeting was held at Delhi on 7/5, and they have filed the affidavit before that. Now, as per the meeting minutes, Lordship, they are supposed to clear all the claims, hospital outside Nagaland by 15 May 2025. 15 May.
So 15 May, that is expired.
Hospital within Nagaland, no fraud by 15 May 2025. Hospital within Nagaland, alleged fraud case flagged. They are saying there's some suspected fraud cases. So they'll clear by 30 May.
The debt has expired.
All has expired, Lordship.
If my lord, may I
We-
Your Lordship, the affidavit claimed to have been filed by the respondent number 5. As far as the respondent number 6 is concerned, we do not have the report of receiving that affidavit.
I'll survey copy. I'll survey copy. Actually, I've handed it over to my local council.
No, but as per your affidavit, when will you comply? If not, we call for the officer.
Lordship, I'll comply, Lordship. I'll seek
When?
instruction, Lordship. I'll seek instruction, Lordship. I'll inform her.
You
Because-
file affidavit, we are
because
giving a
Lordship,
short date.
I have been informed that at no point of time we have never stopped the payment. We have paid, but
Where
but-
is your affidavit?
Lordship affidavit. Yeah.
Where is your affidavit? Affidavit of respondent number?
Five.
Uh, Affidavit of respondent number 4.
It's a bulky one, the 5.
The affidavit of respondent number 5.
Yes.
Lordship, my facts of the case starts from page 5 of my affidavit.
Let's see. Minutes of the meetings. Were you a party to this meeting, 7/5/2025?
Yes, very much. Lordship, in the meeting minute itself, minutes of the meeting held with IRDA, that is Insurance Regulatory Development Authority of India. The DFS is the Department of Finance Service. SHA is the State Health Authority, the state Nagaland state. FGI, Future Generali Insurance. They were duly represented, Lordship, in the meeting.
Smita Tibuliwalo.
The team was headed by, in page 3, Lordship, page 3 of the meeting minutes. Representation from the FGI. Number 4, down number 4, Lordship. Future Generali Insurance India Limited. They were led by their Chief Insurance Officer, then the Senior Vice President, 2 Senior Vice Presidents.
Yes, with FGI committed to a detailed case-by-case review and has proposed the following timeline for settlement of claims. Hospital outside Nagaland, 15th May. Hospital within Nagaland. 15th
No fraud.
No fraud. Hospital within alleged fraud, 30th May. So what action have you taken on this minutes?
Lordship, I have to take fresh instructions regarding.
What instructions? When you have signed the minutes,
Lordship, may kindly fix them.
we call your officer, the
Lord-
highest ranking officer.
Lordship, may kindly fix them at 2 PM. I will get the instruction. Lordship. I'm here. At 2 PM. Lordship.
You go out now.
I'll get the instruction on this.
You go out now and come within half an hour.
Okay.
Yes.
Lordship.
For admission, item number 7.
Lordship, this is not a habeas corpus, Lordship.
Huh.
Lordship, there is only one issue in this case, which is already well covered by decisions of the apex court, Lordship. The petitioner here, he is a life convict, life suffering.
Please wait. Is it a PNDPS case?
No. 302, premature release. He has been in prison since 2009. Under the 2001 notification, he was eligible. And in 2024, another notification was brought out. Now the law is that the notification which was existing at the time the convict was sent to prison, that will be applicable.
This notification 2001 and which notification?
2024, my lord.
2024, which is that, 2024 page 10, annexure page 56.
Yes, my lord.
What is the difference between 2001 and 2004 notification?
Now, under the 2024 notification, Lordship, multiple murders, they are not entitled to for premature release. Whereas under the 2001 scheme, there was no such eligibility criteria. Since his initial arrest on 5th of November 2009, he has been in prison.
And when you were sentenced?
In 2012. But during the trial, he never was enlarged on bail. He is at Central Jail, Dimapur at present. So the representation which was submitted by him was rejected on the ground that under the new notification, he is not eligible, which I've impugned in the present writ petition. At Annexure 9, page.
So you were saying that the notification 2001 applies?
Yes, my lord. And my lord, my only prayer is that the impugned letter may be quashed and the state authorities, state government, may be directed to consider my representation afresh.
In the light of 2001 notification?
Yes, my lord.
But 2024 notification is there.
Yes, my lord.
How can we overcome that?
My lord, the law, lordship, is that the policy that was existing at the time of conviction, that shall be applicable. I may be allowed to place a single decision, lordship.
Yes. Okay, let us.
2010 4 SCC 216, para 54.
This is, oh, this is PIN. Yes, page.
Page 216, the relevant paragraph is at page 239.
239.
Yes, it's a short paragraph.
239.
Paragraph 54.
Yes, 239.
Yes, my
paragraph
lord.
54.
Yes, my lord.
Okay. This is state of Haryana?
Yes,
Versus
what's this
Jagdish?
Jagdish? Yes,
Jagdish,
yes, my lord. I may be allowed to read
Yeah.
paragraph 54. The state authority is under an obligation to at least exercise its discretion in relation to an honest expectation perceived by the convict at the time of his conviction that his case for premature release would be considered after serving the sentence prescribed in the short sentencing policy existing on that date. The state has to exercise its power of remission, also keeping in view any such benefit to be construed liberally in favor of a convict, which may depend upon case to case, and for that purpose, in our opinion, it should relate to a policy which in the instant case was in favor of the respondent. In case a liberal policy prevails on the date of consideration of the case of a lifer for premature release, he should be given benefit thereof. Now, just in order to show that this principle is still holding the field, my lord, in 2024 6 SCC 578, it's a 3-paragraph judgment order. Devnath Singh versus State of Uttar Pradesh. I may be allowed to read para 1 and 2.
Yes.
The state of UP has filed counter affidavit in their alia, stating as under: the government of Uttar Pradesh on 16/12/2021 has decided that the prisoners convicted and undergoing sentence for life imprisonment who were earlier eligible for consideration under the unamended premature release jail policy dated 1/8/2018 will still be considered for eligibility for premature release as per the eligibility before the introduction of the policy dated 28/7/2021. In view of the above, we direct the respondents to consider the case of the petitioner for premature release accordingly within 3 months. So my humble prayer, Lordship, in the instant petition is that my representation for premature release may also be considered.
In the light of 2001 notification.
Yes, my lord, my lord, my lord, that's all.
We passed the order.
My lord, my lord. Deeply obliged.
Miss Mary, you are appearing for
Yes,
the.
yes, your lordship.
Much obliged.
For admission, item number 8.
Lordship, here I may be granted 3 weeks to file my affidavit in opposition. I have taken the consent of the learned additional AG. Miss,
You
Miss
have,
Sokore,
Mr. Senti, you have for respondent 1
yes, my lord, my lord.
on the prayer of Mr. Senti Younger. The learned counsel for the respondent number 1. Listed after
3 weeks, my
3
lord,
weeks for enabling the learned counsel to file affidavit in opposition.
my lord, much obliged.
For admission, item number 9.
Lordship, similar order for 9 and 10. These are analogous matters,
Okay.
similar matters. I'm
Okay.
sorry. Deeply obliged.
For admission, item number 11.
Lord,
Yes.
only this morning I have received a copy of the affidavit which is filed by the central. So,
Filed by
CGC.
by the central.
respondent 4.
Yes, your respondent. So I'm praying for a week time to go through the affidavit.
Mr. Pankir Chabu, learned counsel for the petitioner submits that he has received the affidavit filed by the respondent number 4 only this morning, and therefore 6 for a week's time to go through the same and address the court. Prayer is allowed, listed accordingly.
For admission, item number 12.
Please, your lordship.
Yes.
Lordship, with regard to this writ petition, there is a defect. The lordship may please, please allow me to withdraw the writ petition, with liberty to file afresh.
MS so the learned counsel for the petitioner submits that he has instructions to withdraw the writ petition with liberty to file afresh. Prayer is allowed. Petition is allowed to be withdrawn with liberty to file afresh. MS Inalu appears for the learned government advocate, appears for the state respondent, and Mr. Zatin Muli, learned CGC, appears for
Respondent 4.
the respondent number 2.
For admission, item number
Writ petition disposal.
13.
My place, Lordship.
Yes.
My lord, I pick the yet to receive instruction, so 3 weeks time maybe granted to file a counter affidavit. I'm for respondent number 4.
My lord, here I'm appealing for respondent number 1, 2, and 3,
You
lordship.
file.
Lordship, I'm yet to receive the service copy from the opposite party, lordship.
Yes.
So, which I'm unable to intimate to the state respondent. I'm here to receive this.
Lordship, I'll provide.
Yes.
The first.
Mr. So-and-so. Learned counsel for the petitioner, your good name? Tushitamjan, learned counsel for the petitioner. Shall serve the requisite copies of the writ petition to Mr. Vij Momi, the learned government advocate, when?
Within 2 days.
Within a period of 2 days from today. Stop. Both the learned government advocate as well as the learned CGCs are granted 2 weeks' time to file their respective affidavit listed accordingly.
For hearing, item number 20.
Mr. Jamir,
Lordship.
why don't we take up this case comfortably?
I leave it to your lordships.
Because I think even if even if the hearing is taken up within this short date with all my health issues,
Lordship.
I may not, and even if madam is to write, by that time I'll be out. So whichever, I feel that we list the matter in the third week of June, a definite date, so that I think that the matter can be taken up.
There is a saying, like law and procedure are like a horse. If you go to the front, it bites. If you go to the back, it kicks. If justice delay is justice denied. Justice hurry is also justice worried. So undue haste and delay can compromise the fairness in the justice system. So I absolutely agree with your lordships in whatever
No,
manner.
I
lordship
just
was
want to see
proposed,
that
I agree.
this matter is taken up before a proper bench. Because I have so many disabilities with time and with health.
I understand lordships.
So, yes, Mr. Judge Momi, I think we are going to list this case on 25th. So that there will be no issue as we are having today.
Lordship, I leave to your lordships.
Okay.
convenience.
List the case again for hearing on 25/6/2025. Okay.
For admission, item number 6.
Yes.
Lordship,
Learned Counsel.
since last month we have paid an amount of 10 crores. And presently some amount is remaining, Lordship. They will quote me the exact amount after a while. However,
So
after this meeting.
when can you comply with the
Lordship,
minutes?
I'm
When can
coming to
you
that.
give me that date?
Lordship, after this meeting, we have asked for some mandatory documents from the hospitals, Lordship. They will send me a mail. I will place it on record. Those documents are mandatory and requirement for dispersal of the claims, Lordship. As soon as they provide us, immediately within next 15 days or 20 days, Lordship, till the processing time will take, we will pay, Lordship. We are not against paying, Lordship.
What is the documents which is required?
Lordship, they have sent some detailed mail. I will place it on record, Lordship.
Who has sent? The hospitals?
To the insurance company, to the hospitals, Lordship, asking for some mandatory documents with respect to each particular claim. So after the receipt of those documents,
With regard to each particular claims?
those fraudulent claims, Lordship, or flag cases, Lordship.
Fraudulent claims?
Lordship, if I may be allowed to highlight a little bit.
Hmm.
Now, this suspected fraud cases were raised by the insurance company after the claim was paid to the hospitals. After payment only, they are saying there's a suspicion of fraud. Because as mandated, Lordship, as per the policy, they have to flag those fraud cases before the payment is made.
That's as far as the flag cases are concerned.
Subsequently, Lordship, after we have
But
detected.
what about this first two categories? Paid?
Hospital.
After this meeting,
Yes, hotel outside
10
Nagaland.
crores we have paid, Lordship.
Those within Nagaland.
We don't come in terms of the amount paid, come in terms of this hospital outside
Yes, Lordship,
Nagaland.
I have asked them specifically right over phone. They have informed me, they have sent one mail asking for mandatory documents with respect to each particular claim. As soon as these documents are provided, immediately by the processing time that is required to pay 10, 15, 20 days, they will pay, Lordship.
No, that you're talking about the flagged.
Yes, he's talking about the
claims.
the pending payment.
We are asking you about the first two categories.
First two categories, Lordship,
Yes.
they have informed me that they have paid almost 10 crores in.
We are just passing a very simple order to comply with this.
Lordship, may permit me to file a subsequent additional.
You cannot just sit over this matter because actually if you sit over this matter, this has actually very severe and adverse consequences so far as the public in the state of Nagaland is concerned, especially the sick.
The sick
Yes. So we cannot allow you to, we cannot give you time allowing you to give us this and that reason. I think that is, we give you time
4 weeks, Lordship.
to comply with this minutes, especially the key decisions.
Yes.
Lordship.
Lordship, but in the meantime, let the documents may.
We are not bothered about that. We are not bothered. We just want you to comply as per the meeting minutes.
Yes.
And if not, we call your officers.
Lordship,
We have to take a very serious action.
4 weeks. Lordship, in the meantime, we will pay, Lordship.
In the meantime, within this 4 weeks, what is supposed to be done? Do it.
The documentation.
Do it. Do it. But don't give us all these reasons. We want to see that actually you actually comply with the minutes of the meeting.
Because we have already, it's even minuted, Lordship. If there's any recovery to be made, the state will do the recovery. If there's any fraud case, we have given assurance, Lordship, to the ministry also.
So the state is the guarantor.
Yes.
What better guarantor you want? When the state has actually guaranteed to
Yes.
pay any fraud amount which has been released
Yes.
by the insurance, what better guarantee you want?
We have done in some cases, Lordship.
And that is actually not to disturb the scheme. If there is any fraud, that is between the state government and between the insurance to work out.
Correct, Lordship.
That's all. Simple as that. So don't give us that.
They are public money is involved basically. That's why they are.
No, public
concerned.
money, we know, public money. But actually, why actually this, why, for what reason this money was given to you? I think that also is very important.
Yes. True, Lordship.
So we are really concerned. And if on the next date, we give you time within that, you finish all your paperwork, and if within that time, nothing is forthcoming, then we will have to call your, the highest officer in your, this insurance. Where is that petition? Where is the copy of that petition? This petition? This thing, the petition is not here. Okay, okay. No, it is not here. The petition. Where is the petition? This is affidavit in opposition, respondent number 6. This is affidavit in opposition, respondent number 5. This is affidavit on behalf of respondent number 4. That's all. Mr. Joshua, you are for?
Respondent number 6, Lordships.
So respondent number 6 is?
Private hospital.
Private hospital.
In Bangkok.
Okay. You are still actually, I think, giving the benefit under the CMHIS, or some other things have been worked out.
Lordship, what has happened, the insurance, the previous insurance was FJ, the present respondent number 5. The tenure has ended on 31st March. So we have bought a new insurance company.
Okay.
So we are going to have a new MOU with them. The policy has already started.
No, what about the money released by the all insurance that is being paid to the hospital? Is the hospital receiving?
They
Small amount.
Whatever small amount, let us say, you are receiving.
Yes, Your Lordships.
Okay.
But I'm surprised that the claim made in their 9th of May affidavit, which we are yet to receive the copy of the submission of my learned friend, even that also actually requires a rejoinder, but.
9th of May, who's affidavit?
Lordship, I will furnish it today itself.
They will furnish today.
Respondent
I have my
number,
notes, direction today.
respondent number,
Fine, Your Lordship.
Private respondent number 5.
respondent number 5.
Hello.
Okay, you give a copy.
Today
We'll,
itself.
we'll record it. But we are not very much on this.
Yes.
We are only on, you are
Compliance.
making, the payment in full. That's,
Seven
that is what, we are concerned. Yes, where is the copy of the petition? This is missing. It's not. What is FGI?
Future
Future generally insurance.
You just tell the judicial section, okay? This is missing.
Lordship, may kindly see the 14th February order. The gist of the case has been highlighted in that order also, the day of motion.
14 February.
14th February, yes. The gist of the case has been explained,
14 February order.
yes, first order, passed by this court. 14th February. Yes, Lordship, I have a copy of the order here.
Yes, yes, wait, just 14-2,
Yeah.
correct? Hmm. Sure. Okay. MS. Kiki.
Lordship.
Your full name is Kiki.
Lordship, it's Miss Kejosano Kiki, but
Miss-
for the convenience
Miss-
of this court,
Ke-
this is your Lordship.
Miss, okay, MSK Kiki, the learned counsel for the petitioner. State, Mr. Imti. Mr. Imti Im Song, the learned additional AG for the state respondent number 1, 2, and 3. Mr. Muzui, for.
Standing counsel for respondent number 4.
Mr. N. Muzui, Learned Standing Counsel for the respondent number 4.
Mr. A Kakoti for R5.
Mr. A. Kakuti for the respondent number 5. Mr. Joshua Shaki, Learned Counsel for the respondent number 6. And Mr. So-and-so, Learned Counsel, appearing on behalf of Mr. Yangarwati, Learned CGC, for the respondent number 7. What is this, IRDAI?
Insurance.
That is the regulatory body of insurance companies across India.
Insurance Regulatory Development Authority of India.
We have, stop, new para, we have perused the minutes of the meeting dated 7/5/2025. Held with IRDAI, DFS, SHA, SHA, is it SHA Nagaland?
Yes, and
SHA Nagaland, FGI and FGI under the chairmanship of the Joint Register
Joint Secretary,
or Joint Secretary,
National Health Authority,
National Health Authority,
Ministry of Health,
Ministry of
Health and Family.
Health and Family Welfare.
Lordship, may I come to agenda? That is the issue where in the first page, Lordship, agenda. Second paragraph. This was the main point where the issue was.
Is reproduced herein below. Okay. I'll flag it. The entire thing, okay. In the minutes of the meeting, though the FGI, that is the respondent number 5, has proposed certain timelines for settlement of the claims with regard to the 3 categories of cases. The respondent number 5 has not been able to finalize the settlement as proposed in the minutes of the meeting dated 7/5/2025. We accordingly direct the respondent number 5 to finalize the settlement of the claims as incorporated in the minutes of the meeting dated 7/5/2025 within 4 weeks from today. Okay? 4 weeks from today. The respondent number 5 shall on the next date fixed file proper affidavit stating finalization of the claims. Stating finalization of the claims as incorporated in the minutes of the meeting dated 7/5/2025 in the form of an affidavit. Stop. Any issue with regard to the settlement of the claims shall be worked out between the respondent number 5 and the government and the
Respondent 4.
and the respondent number
6.
and the respondent number not 6 and the respondent number
5 is the
5 and
4.
respondent number
4.
shall be worked out between the respondent number 5, between the respondent number 4 and 5. Okay? If there is any issue regarding the
yes,
settlement,
Lord.
you sort it out.
Yes, Lord.
But actually, that should not have any bearing on the amount which is to be paid to the private hospitals.
Yes.
Okay? Listed again on?
Because of first week and second week is vacation. So 16 on real.
Yes, we are giving you sufficient time, so just kindly
I'll
settle all the claims. Listed on 16/7/2025.
On the next day, if they fail to comply with the fees.
No, that will actually we will decide on the next day. I think let us not count the chicken before it is hatched. Okay.
Your Lordship.